Hi guys, this is a run through of a torts question for the MBE release questions, and we are going to start out with going through the call of the question first, then the fact pattern. The call of the question is in an action by the gardener against the golfer to recover damages for the harm of his plantings, the gardener will. When you read the call of the question, the thing to know was the gardener against the golfer to recover damages of the harm. When you see that, it indicates either a contracts, property, or torts questions, because this is what I call fighting types of a fact pattern, it seems like. So you don't know exactly what it's talking about just yet, but you go to the fact pattern and it says a gardener's backyard, which is landscaped with extensive flowers and shrubs, is adjacent to a golf course. While the golfer was playing golf on the course, a thunderstorm suddenly came up, and at this point, you should see with the thunderstorm suddenly came up, that is an indication that it's a torts question, and you could probably be certain now that it's a torts question by this time. Then, as you move on, as the golfer was returning to the clubhouse in his golf cart, lightning struck a tree on the course and the tree began to fall into the golfer's direction. In order to avoid being hit by the tree, the golfer deliberately steered his car onto the gardener's property, causing substantial damage to the gardener's expensive plantings. Those are really important things to know, because now what you'll be thinking is, okay, it's a trespass, a necessity. When you think of necessity as a defense to trespass, you should think of the public versus private. And as far as the liability issue of it, because that's what the call of the question was about, the golfer wanting to recover damages for the harm to his essentially property. This sounds like a private necessity because there is no public emergency here. Therefore, it's a private necessity. And with a private necessity, as far as damages, you need to pay for actual damages. So in this case, the call of the question in an action by the gardener against the golfer to recover damages for the harm to his plantings, the gardener will. I'm going to favor the two prevail answer choices because there's damage and it's a private necessity. Therefore, the defendant is going to be required to pay actual damages. The first answer choice for prevail says that the golfer is liable. The gardener will prevail because although occasioned by necessity, that matches up, there is a necessity. The golfer's entry onto the gardener's property was for the golfer's benefit. That matches up with the fact pattern, and it highlights what we had been thinking about, which is a private necessity. And so that looks like a pretty good answer to me. So we'll keep that in mind. The next answer choice says prevail for nominal damages. This goes against what we read in the fact pattern of causing substantial damages. So it doesn't really fit with the fact patterns. Not as happy about that answer choice because the golfer was privileged to enter the gardener's property. Yes, that is true. However, it was a private privilege, so they are supposed to pay actual damages, and it sounds like there's substantial damages because these plants are expensive plants. Therefore, nominal damages you only get if there is no damage to the property. That means that B doesn't match up as well with the fact pattern. For C, no prevail, do not prevail because the lightning was an act of God. When we're talking about a lightning was an act of God, that is a superseding cause answer choice. This is an intentional tort. The superseding cause tends to show up more in negligence situations as far as the MBEs are concerned. The superseding cause is, in a sense, a defense against negligence. So it doesn't really apply here because the lightning did cause something, but the cause was for him to enter onto the gardener's property, which means that we are dealing more with trespass, and the cause of, or what the lightning caused, really is irrelevant at this point. So not really liking that answer choice. So that should probably be not a choice to pick. Then D, not prevail because the golfer's entry onto the gardener's property was occasioned by necessity and therefore privilege. The necessity language sounds good, but this is what I would call an answer choice that is an incomplete analysis type of an answer choice, because it does talk about necessity and privilege, but when we talk about necessity in terms of trespass, you want to consider both public or private necessity. So not liking that answer choice as much as the answer choice in A. A fits the best. That would be the correct answer. Um, A, the gardener does win because even though there was a necessity, the defendant will have to pay for actual damage to the gardener's property. Now we'll run through the MBE question, going through the fact pattern first, then the call of the question. The fact pattern starts out: a gardener's backyard, which is landscaped with expensive flowers and shrubs, is adjacent to a golf course. While a golfer was playing golf on the course, a thunderstorm suddenly came up. As the golfer was returning to the clubhouse in his golf cart, lightning struck a tree on the course and the tree began to fall in the golfer's direction. This looks like a torts question because of the thunderstorm suddenly came up. That would highlight a torts type of fact pattern. In order to avoid being hit by the tree, the golfer deliberately steered his car onto the gardener's property, causing substantial damage to the gardener's expensive plantings. The lightning striking the tree and the tree falling in the direction of the golfer is highlighting a torts, confirming that this, you should note that this is a torts question. When it moves into the golfer deliberately steered his car onto the gardener's property, that is now a trespass situation. Not only that, but it is a necessity, and it's indicating a private necessity because we're not seeing any public necessity, any public emergency. Therefore, we're talking about private necessity. It continues on to say, causing substantial damage to the gardener's expensive planting. Substantial damage is important because with a private necessity, you are still liable for actual damages to the property itself. So keep all of those things in mind for when we read the call of the question, which is in an action by the gardener against the golfer to recover damages for the harm to his plantings. The gardener will, and words to note would be the gardener against the golfer to recover damages. And if you had already thought this is going to be actual damages because of the fact that the golfer had to get onto the land because of the lightning striking the tree, falling close to him in his direction. It's a private necessity. And so at this point, you should be thinking the gardener will win because there is trespass. Even though there's a necessity, the trespasser still needs to pay actual damages. So I would be favoring the two prevail answer choices, um, which would be A and B. A says because although occasioned by necessity, prevail because although occasioned by necessity, the golfer's entry onto the gardener's property was for the golfer's benefit. That sounds like it matches up with the fact pattern because we had thought about it being private necessity and that they need to pay for actual damages. So that's looking pretty good for the golfer's benefit. That's looking to be pretty good. The second answer choice in B says that the gardener will win for nominal damages only because the golfer was privileged to enter the gardener's property. With respect to the nominal damages, you would only need to pay nominal damages if there is no damage to the property. In this case, the fact pattern did say there was substantial damage to the plantings and they were very expensive plantings. So that's not looking as good of an answer choice as A. I would pick A over B. Then for C, says the gardener does not win because the lightning was an act of God. This is a superseding cause argument, and it would be a defense that the defendant would have available, but in a situation where the lightning actually caused the damage. The lightning in this case didn't really cause the damage. What it did was just it caused him to commit the trespass, and he has a defense for trespass, which is necessity. So the defense here really is an irrelevant defense. So C is not a good answer choice, especially since you have A, which matches up very nicely. Then for answer choice in D, it says that the gardener will not prevail because the golfer's entry onto the gardener's property was occasioned by necessity and therefore privileged. The necessity and privilege, it is matching up a little bit with the fact pattern, but what it is not considering is the difference between the two necessities. We had spotted the issue, or you should have spotted the issue, that this is a private necessity. This answer choice does not take into account the private versus public analysis of the necessity. So it's what I would call an incomplete analysis question, or an incomplete analysis answer choice, which makes it not as good as the other answer choice in A that looked pretty good when we first saw it. Therefore, A would be the correct answer. Now we'll run through the same question with the call of the question, then look at the answer choices, and then the fact pattern. The call of the question is, in an action by the gardener against the golfer to recover damages for the harm to his plantings, the gardener will, the words to know would be the gardener against the golfer to recover damages for the harm to his plantings. This is looking like it's either going to be a contracts, property, or torts question. Those are what I call the fighting subjects, where you have a plaintiff against the defendant and they're usually fighting for damages generally. Then when you read the answer choice, A prevail because although occasioned by necessity, the golfer's entry onto the gardener's property was for the golfer's benefit. We're seeing necessity. We're also seeing, at this point, when you see necessity, you should note that it's looking like a torts answer, torts type of a question. Then the golfer's entry onto the gardener's property, that indicates a necessity situation, or I guess a gardener entering onto the property. It highlights the trespass, and since they also mention necessity, that matches up to the defense for trespass. Answer choice Answer choice B, prevail for nominal damages only because the golfer was privileged to enter the gardener's property. This answer choice is looking at um, this answer choice is looking at the nominal damages, and if you are thinking of the golfer privileged to enter the gardener's property, they're highlighting the trespass, and you don't get more than nominal damages if there's no damage to your property. So make a note of that. Answer choice B would be a good answer choice if there was no damage to the property in the fact pattern. Then for C, the gardener would not prevail because the lightning was an act of God. This is highlighting a superseding cause type of fact pattern. So if there is a causation analysis that's triggered by the fact pattern, this would be a good answer choice. The last one is not prevail because the golfer's entry onto the gardener's property, again, this is the trespass it's highlighting, was occasioned by necessity. It's also highlighting necessity, therefore privileged. So answer choices A and D are highlighting the necessity element of trespass. Now, when you go up to the fact pattern, you see a gardener's backyard, which is landscaped with expensive flowers and shrubs, is adjacent to a golf course. While golfer was playing golf on the course, a thunderstorm suddenly came up. The thunderstorm coming up as the golfer was returning to the clubhouse in his golf cart, lightning struck a tree. That is now highlighting the answer choice that has the superseding cause with the lightning strike. So that helps with that type of an analysis if you are looking at the lightning being a cause of some type of an injury. Right now, we're not seeing it yet. The next part was saying that as the golfer was returning to the clubhouse in his golf cart, lightning struck a tree on the course, and the tree began to fall in the golfer's direction. In order to avoid being hit by the tree, the golfer deliberately steered his cart onto the gardener's property, causing substantial damages to the gardener's expensive plantings. This is highlighting that the lightning strike caused the tree to fall, but the tree falling in the golfer's direction, it didn't say anything about damages. So that superseding cause, we're not really caring about that as far as the fact pattern is concerned, because immediately after that, the fact goes on to say, the facts go on to say that in order to avoid being hit, they're highlighting the trespass and the necessity. So A and D are looking better than C. Now, when you look at how they're saying about the trespass, when you're thinking of trespass, you should be thinking of you should be thinking of some of the issues that surround the trespass that they tend to test on. And in this case, they're probably highlighting the necessity element of it. And so you want to now narrow it down to answer choices A and D. Those are looking like they're matching up a little bit better than, and you can eliminate answer choice C because we're not caring about what the lightning is causing because it's irrelevant at this point. Then, as far as you can see with as between answer choices A and D, answer choice A is really highlighting that trespass private necessity aspect of it, which matches up really well to the fact pattern. Answer choice D, although it highlights the necessity element, it is what I would call an incomplete analysis of necessity because when you look at necessity, you should always be considering, is this a public necessity or a private necessity? And if you have an answer choice A available, that is a much more thorough analysis and which tends to be the better reasoning for your conclusion than answer choice D. And so you would be able to eliminate answer choice D. Answer choice B is still sitting around there. If you look at answer choice B, it does have that nominal damages, and you should know that for trespass, you only get nominal damages if there is no damage to the property. And in this case, the fact pattern specifically tells you that there is substantial damage to the gardener's expensive plantings. Therefore, that's not looking like a good answer choice. And your answer choice would be answer choice A.